Good morning to everybody. Miss Wiesenthal, are you ready to go?
Yes.
And Miss Federico, are you ready to go?
Yes.
Okay, we are on the record in the Colorado Public Utilities Commission's proceeding number 24R-0078 GPS. My name is Connor Farley. I am the administrative law judge assigned to this proceeding. And it is approximately 11:32 a.m. on April 15th, 2024. This remote public comment hearing was scheduled in a notice of proposed rulemaking, otherwise referred to as a NOPR, which was decision number C24-0099 that issued on February 21st, 2024. This remote public comment hearing was scheduled to allow members of the public to provide comments regarding the proposed amended rules as outlined in the NOPR. I want to welcome and thank each of you for being here and participating in this rulemaking and providing the commission with the benefit of your wisdom regarding these proposed rule changes. And let me just state as well that as we go through this remote public comment hearing, if at any time I mispronounce a name or refer to someone by an incorrect gender pronoun, I apologize and mean no disrespect. Please simply correct me and I will endeavor to get it right from then on out. So there have been written public comments, both an initial round and a response round that have been filed. I have read them and am familiar with them. This remote public comment hearing is there are two general purposes of it. One is for me and the commission to receive any further public comment. And the second is for me to ask questions of those who provide public comment, even including those who have already submitted written comments. And I plan on doing some questioning regarding the written comments that have already been submitted. But in terms of providing written comment, let me give some background and some direction for everybody about how this will proceed. As a general matter, regarding public comment, people can provide either written or oral comments. Both will be given the same weight. The commission does not give any greater weight to oral or written comments. However, the commission tends to prefer written comments because many of us are clearer and more persuasive in our written communications than in our oral communications. So if anybody out there would prefer to provide written comments rather than to provide the same comments orally today, there are at least four ways of doing so and submitting them to the commission. One is you can send written comments by email to the following email address. It is Dora_PUC_website@state.co.us. Another way in which those who want to provide written comments can do so is through the Commission's website. The website address is puc.colorado.gov. Once you hit the landing page, you can scroll down until you see the box labeled File a Comment or Complaint. You click on that and a form will pop up. And when applicable, you'll need to select this proceeding number, which is, as I stated at the outset, 24R-0078 GPS. So that's another way to submit public comments. Once you go through that process through the Commission's website, you'll be able to provide your written comments. Another way that you can provide them is through the old-fashioned U.S. mail, and you can send them by U.S. mail to the following address of the Public Utilities Commission: 1560 Broadway, Suite 250, and that's in Denver, Colorado, and the zip is 80202. Yet another way that people can provide what end up being written comments is to call the following phone number. It is 303-869-3490. Once you dial that number, you can leave an oral comment in English or Spanish, and then that oral comment will be transcribed, in other words, written down by somebody, including by a Spanish to English translator, and then that written document will be placed in this proceeding. So that's another way to provide written comment in this proceeding. With respect to all of these options, it is critical that you identify this proceeding number, which again is 24R-0078 GPS. By providing that proceeding number, the administrative folks at the Public Utilities Commission will be able to place your written comment in the proper proceeding. They will file it for you in the proper proceeding. If you don't include that proceeding number, it makes it a lot more difficult, and there's a chance that I will not have the opportunity to read it. If you nevertheless want to provide oral comments here today, please follow these steps. Looks like most, if not all of you have already done this, but change your Zoom name to your first and last name. This is important for a clear record and so that I can call on you. You can use the raise hand Zoom feature or feature in Zoom to signal you wish to speak. To do so, you need to click on the reactions button at the bottom of your screen and raise your hand. If you no longer wish to speak, please lower your hand using the same process. Please remain on mute with your camera turned off until your name is called. If you do not know how to use the raise hand feature that I just described to you or can't figure it out, you may instead turn on your video to signal to me that you wish to speak. To any who may be participating in this hearing by telephone, you will need to dial *9 to use the raise hand Zoom feature. Please then listen very carefully for your area code and the last 3 digits of your phone number. When your number is called, you will need to dial *6 to unmute yourself. And the reason why it will be your area code and last 3 digits is because that's what I see on my screen. When I call your name or phone number, please unmute and turn on your video. And then please begin your comments by stating your first and last name. That will be helpful to me most immediately. It will also be helpful and important for our court reporter, Ms. Wiesenthal, who is transcribing everything that's said while we're on the record here today. So stating your first and last name will be very helpful because then she'll be able to identify who's saying what. So just a few tips on presenting comments orally. One is an elaboration on part of the last point I just made, which is we do have a court reporter here who's taking down, transcribing everything that's said while we're on the record. It's important for all of us to try to speak slowly and clearly so that Ms. Wiesenthal can get an accurate record. It may be that I'll be compelled or feel compelled to interrupt you at times to the extent that you're speaking too quickly or not clearly enough. Second point is that all of our statements, while we're on the record during this remote public comment hearing, need to be verbal. To the extent I ask a question, an answer, a nonverbal answer with shaking your head one way or the other doesn't work, because Ms. Wiesenthal cannot take down, cannot transcribe that statement. So try to keep in mind that all statements need to be verbal. And also, please try to avoid speaking over top of each other. That goes for me as well, obviously. But Ms. Wiesenthal will have a difficult time getting an accurate transcript to the extent we're talking over top of each other. And finally, if anybody covers all the points that you want to make, please feel free just to make that point during your oral comments, and don't reiterate what somebody else has already said. That will make for a more efficient hearing. With that, why don't we dive right in, and let me just start with kind of an issue that may fall at the end of this, but let me bring it up now, which is I believe, well, I can't remember if it was in the initial comments or response comments by Black Hills. Black Hills asked for, now I'm quoting, sufficient additional time to allow the interested parties to confer in order to develop consensus blue line rules that can be submitted for the commission's consideration. My initial question is, do others feel like that would be a good approach? In other words, well, at the end of this, to continue the hearing until a later date, and perhaps a few months in the future, to allow everybody who wants to, in particular the people and entities that have submitted comments so far, to go through a meeting process of trying to reach consensus rules that everybody can agree to. Let me just start with Black Hills and ask, have I characterized that accurately? And to the extent that was a request made in your initial comments, do you still stand by that request here today?
Good morning, Your Honor. Emmanuel Koshin for Black Hills Energy. Interestingly enough, with the blue lines that were submitted with Piesco's response comments, the company is much more comfortable where the rules currently sit. There are still a couple small issues or concerns that I think might be addressed a little bit better if the parties had a little bit more time, such as the definition of owner and operator, whether that needs to be in the rules, whether mainline needs to be a defined term. So I think we are much further along than we were with Black Hills when Black Hills filed its initial comments. But I think some additional time would still prove helpful in developing a set of consensus rules that could be submitted and agreed to by the majority of the parties, maybe all the parties.
Okay. So let me just open the floor and see if anybody else has a reaction to that. And don't worry, we're going to go through the comments that have already been made, if for no other reason than to give me some, get me some answers to questions that I've raised. So it looks like public service. Is that Mr. Akins? Sorry, I'm not seeing. Yep, go ahead, Mr. Akins. Please unmute yourself, turn on your. Thank you. Welcome. And why don't you go ahead?
Yeah, good afternoon, Judge Farley. Just for the record, my name is Christopher Akins. I work with Excel Energy as the Director of Operation Standards. I oversee the development of electric and gas standards for Excel Energy, and as part of my responsibilities, my team oversees pipeline safety regulations and industry best practices for the 7 states that we operate our natural gas facilities in. In response to your question, Public Service has submitted our Blue Line proposed edits, and we don't think at this time it is necessary to have all parties convene, but we would certainly appreciate any feedback on our proposal. And certainly, as Emmanuel stated, there may be some items that we could discuss after we get through the public hearing today. So thank you for that.
Thank you. And I'm not sure that we've met before, so it's nice to meet you. Anybody else have any thoughts on the proposal by Black Hills? Okay, I'm not seeing anybody with any thoughts. So we'll address this, I guess, then at the end of this public comment hearing about next steps. But I just wanted to start there to see whether there was a groundswell of support for Black Hills proposal, because that could have had an impact on the course of this public comment hearing. So let me just jump right in. And Mr. Kosian, I'll turn to you again. In your initial comments, Black Hills made a comment, and I'll just quote it to you. The commission should not abrogate its duty to ensure that the rules adopted are unambiguous. And that was at page 2 of your initial comments. And I'm not sure that you really went on after that and made clear exactly what you mean by that, but I thought I'd give you the opportunity to provide some detail on that. I'll say that I think others have made the point essentially that I think the statutory language that we're attempting to implement here, I think I saw somebody who I won't name say something like it's less than ideal or something to that effect. So I guess, Mr. Kosian, I'm wondering whether that was your point in the sentence that I just read.
That is correct, Your Honor. Oftentimes, when the legislature develops statutes, sometimes they're not as well versed in what occurs within the industry that they're legislating for. And as was probably clear in our initial comments, we were confused, and we were hoping that the commission wasn't going to simply adopt the legislation and plug that into the commission's rules. I think that approach would have resulted in substantial confusion, substantial ambiguity, and as was, I hope, clear from our response comments as we were reading other comments and other proposals, there were ways to clarify what the legislature wanted the commission to do with the opportunity to eliminate some of that ambiguity. And the purpose of that language was exactly as you indicated. The legislation was not quite as clear as it could have been, wasn't ideal. And so we are hoping that that legislation is not adopted as written.
Okay, so I have one follow-up question for you, Mr. Kosian, and then I'm going to open it up to everybody else. So I understand the point made by several that we've been discussing. The question ultimately is, what authority does the commission have to basically eliminate language from, for example, statutory definitions in an attempt to clarify them? So I'll give an example of what I'm talking about. So I think everybody is pretty much on board with changing the statutory definition of gas meter in the legislative changes that we're attempting to implement here. And the statutory definition is that a gas meter means the meter that measures the transfer of gas from an owner or operator of a customer-owned service line to a customer. And so, for example, I know Black Hills has proposed to just delete the of a customer-owned service line from that definition. And the question I ultimately have is this within the authority of the commission to do? And I understand the argument that several have made that including that clause of a customer-owned service line at a minimum creates ambiguity. At a maximum is just flat out wrong. Anybody have any thoughts? Anybody have any authority that they can cite to me, or perhaps, well, let me leave it there.
Your Honor, Nick Stoffel for Atmos Energy.
Welcome.
Thank you. So I guess I'll take the first crack at answering your question here. So I think we recognize you do not have the authority to change the definition in the statute. That is how the term is defined for purposes of the statute as used in that section, unless context otherwise requires, or as otherwise defined in the commission's rules. So I think actually in this instance, you do have some flexibility about how you define the term meter in the commission's rules. And then I think the other way to go about it would be if you end up needing to have more than one definition, if there's one that needs to track what is in the statute and one that addresses circumstances that are not addressed by the definition in the statute, that would be another way to navigate this puzzle that we have with the definition in the statutory language.
So regarding that last point, Mr. Stoffel, it's one thing maybe you're suggesting to have a definition of meter and another definition of gas meter and keep the gas meter definition consistent with the statutory definition?
Something along those lines. I mean, the definition in the statute clearly is tied to this customer-owned service line or customer-owned yard line. There's obviously some discussion about exactly how that should be defined in the rules too. But you could essentially have like a coil gas meter and gas meter as a way to distinguish between the two to honor the statutory language if you found it necessary to have kind of that nuance reflected in the commission's rules.
Okay.
But as indicated, I think the statute actually does provide some flexibility just in terms of how the definitions are introduced.
All right. Thank you. Anybody else have any thoughts on this? All right. Well, go ahead, Mr. Akins, if you would like.
Yeah, thank you. Just wanted to point out two things. First, in the statutory language, it does state that the commission's gas pipeline safety rules pursuant to this section must permit any activity that is within the best practices and standards for the industry. So we just want to clarify that, a lot of the clarifications that we're making to the definitions are to remove that ambiguity and to align with definitions either on the federal part or within other rulemaking in the Colorado level. So as it stands right now, given that you'd be having the ability to remove a lot of that confusion, I think would still be permitted within the statutory language. And again, could go a long way making sure that the rules are readily understood and in alignment with other rulemaking. Thank you.
Okay, and that's interesting. So I guess what you're essentially saying, at least in part, is these modifications to definitions are necessary in order to keep the rules consistent with the best practices and standards in the industry.
Yeah, that's correct, Your Honor.
All right.
Thank you.
And that latter language is statutory as well, and it's included in the rules, which I know a few of you perhaps have issues with. Proposed rule 11206G, I think is where it is. Okay. All right. All right. Well, anybody else? I'm not seeing anybody, so I'm prepared to move on. But last chance on this point. And as we go forward, and to the extent you all are given, which I believe you will be, additional opportunity to file written comments, to the extent anybody wants to research and include in written comments the authority that I've been asking about here. In other words, the authority to essentially modify the statutory definitions, which are part of what we're attempting to implement here. Anyway, if anybody wants to take a shot at that, legal authority and/or legal argumentation, that would be appreciated. I see Mr. Dixon is.
Well, I didn't get to my hand raised. I was going to say, the commission can interpret definitions. One thing I thought of is with regards to the customer-owned service line, I think the commission could also put in its definition, also known as customer-owned yard lines, since that has been the term of art that's been used within the commission. With respect to what's been proposed, I agree that given the flexibility, if it indeed is interpreting what that definition means, that's clearly within the purview of issuing rules, is to provide interpretation, so long as it doesn't totally change the definition. So I would suggest that to the extent the definition can be interpreted and could be defined more clearly, I think that's totally proper, as long as it doesn't, remove the definition or modify it. So I would suggest under that circumstance, we might be able to do things through interpreting the rules and doing a rule that interprets what the commission will use to determine what a gas meter, likewise, that a customer-owned service line and a customer-owned yard line are the same, that type of stuff. And I haven't thought about this in detail. I'm just going on past rulemakings.
Understood. And that all makes sense. And I agree with you, Mr. Dixon. I've already pointed to the one definition that really leaps out at me. It's the definition of the gas meter. And it seems to me, just to be frank and just lay it on the table, that in order to adopt the proposed change to the definition of gas meter proposed by Black Hills, for example, looks like it's changing the definition. It does look like that well, there's an argument to be made that the legislature just made a mistake in defining gas meter. But in any event, that's what I'm struggling with a little bit, is figuring out how, what is the source of the authority for me to basically eliminate statutory language which has an impact on the meaning of the definition. So anyway, you all have heard me. To the extent you want to help me out, that would be most appreciated on this in future written comments. So let me move on, and let's start with another more general comment regarding the definitions. And again, this was Black Hills comment, and what Black Hills was proposing, at least in its initial comments, was to consolidate, well, to basically eliminate proposed rule 11205 containing all the definitions and consolidating them under existing rule 11001. 11001 provides definitions, more generally for the entirety of the pipeline safety rules. Section 11205 is the new section applying to customer-owned service or yard lines. Mr. Kosian, I see that you popped up. Why don't you go ahead? But I'm also looking for, I know that Colorado Springs Utilities noted this request, Mr. Kosian. I'm not sure. I think Colorado Springs has been, well, I think they're fine with it either way, but why don't you go ahead, Mr. Kosian?
Your Honor, as we were going through this, reviewing comments, that is one of the suggestions we made in initial comments, but I think it actually probably is better placed as a separate set of definitions specific towards customer-owned yard lines, customer-owned service lines, whatever the outcome of that is. And I would point out the term qualified is used as an example in the Commission's gas utilities rules in several different places, and does not quite fit with the definition that's found in 11205F. And so the company does wish to walk back its suggestion from initial comments.
Okay. Thank you for that, Mr. Kosian. I take it your last comment, Mr. Kosian, was essentially they should be in their own discrete section under the existing proposed section, but to the extent there is any tension or creation of ambiguity by including words or terms that apply in Rule 11001, that we should endeavor to make them consistent. Is that fair?
I think that is fair. Yes, Your Honor.
Okay. All right. Anybody else want to weigh in on this? I didn't see anybody, I don't think, other than Colorado Springs Utilities, note and provide some support at least to Black Hill's initial proposal. So anybody else want to weigh in on this? Okay. All right, so let me move on to 11205A alpha. That's the definition of the proposed definition of customer-owned service line. I've read all the comments about this. Colorado Springs Utilities came in and made its own proposal. So I guess what I'd like to do is give everybody the opportunity to react to Colorado Springs Utilities proposal. And the major part of that proposal is to change the term customer-owned service line to customer-owned piping. So does anybody else have any reaction to that or anything else that Colorado Springs Utilities said along these lines?
Again,
Go ahead, Mr. Dixon.
I was going to get my hand raised. Sorry. Again, I think if there's another term of art that's used that means the same thing, I think in the definition of customer-owned service line, the commission can also state that it is also known as customer-owned yard lines, or if it's a federal definition of customer-owned piping, that these terms are basically synonymous. If in fact that's the case, and that's what I'm seeing from, as they refer to themselves, the Colorado Springs Utilities, the Springs Utility. So again, I think that kind of clarification simply points out so people know what different terminology really means in terms of these rules. And I thought about it with your definition of gas meters. And given, when you're ready to go to that, I have another thought. So I'll leave that to you.
Okay, well, why don't you go ahead now, Mr. Dixon?
Well, Black Hill's concern is that it gives the impression, the way it's written, that the utilities own the customer-owned yard line. I think the rule can very clearly state, in interpreting that definition, that the commission does not, that the customer-owned yard lines are not owned by the owner or operators, and just say that clearly. If that's the fundamental issue, that can be clearly stated, and that's not changing the definition in any way, shape, or form.
Yeah. Well, and I would think that the customer-owned part of the definition helps in that regard.
Right. I mean, and clearly that's been the rule. I mean, so again, as you said, perhaps there was inartful drafting, but we can clarify that customer-owned yard lines are not owned or operated by the utilities. And that would be a clarifying rule, and it's an interpretation, and it doesn't change the definition at all.
Okay. All right, anybody else have any thoughts on this? Go ahead, Mr. Akins.
Yeah. Hi there. I think back to your original question, if the term customer piping as proposed by Colorado Springs would be acceptable, I think, again, as mentioned, our principal concern is that just the confusion with the terminology, and inherently just when we use the term service line, we're talking about the upstream portion from the meter that the utility company owns. So I think, our concern is predominantly getting away from that. Customer piping terminology isn't defined. I just want to clarify in the federal definitions. When looking through the preamble of that rulemaking 192.16, which refers to customer notifications of customer piping, PHMSA elected not to define the term, but they did intentionally steer away from the exact terminology of customer-owned service line, which was proposed in their legislative language and is still in statute to this day. So I think they arrived at the same conclusion, which is that the terminology is confusing and that it's, better stated as customer piping, or in our opinion, as COYL, customer-owned yard line. We think customer-owned yard line gets to the point a little bit more specifically for what we're after here, and it also aligns with other rulemaking, particularly the GIP rules out there for consistency as well. So our preference is still to use the COYL terminology. And again, I just wanted to point out that customer piping is used in the federal definitions, but not defined. And again, still not our preference in this rulemaking. Thank you.
All right, so public service wants customer-owned yard line. That's still its preference. I think I heard you say.
Correct. Yep, that's correct.
Right. What about, let me ask you, Mr. Akins, this whole concept of it having to be buried in order to be a customer-owned yard line. I mean, I both understand it and I don't understand it. Is there no situation in which there's a gas meter remote from the structure in which the piping downstream from the meter is above ground?
Unless they laid the piping on the physical ground, which I believe would be against the fuel code requirements, no. They would have potentially maybe a meter set at a structure, and then they could run above ground piping maybe around the building or around the building and then below to service some other appliance or structure. But no, I think our concern is that we really want to clarify the buried portion, particularly as we get into the requirements for notification. And again, looking at the preamble for the federal rulemaking that took place, they were very much aware of that same issue, where if you have even a small segment of above ground piping from the customer meter that's set at, the gas meter set at a customer premise going into the building, you could always have some portion of above ground piping. So, the buried portion we think is very critical to understanding the rulemaking and to framing when the notification process is in place, and also to identifying, where really we need to convey the responsibilities to the customer to do additional actions for maintenance and repair. So hopefully that helps clarify for you.
So I think it does, but why don't you stay there? I mean, I think what you're saying is the buried portion, at least in part, the buried portion is the highest risk portion in this scenario. I mean, there's no dispute that all piping, everything downstream from the outlet of the meter is the customer's responsibility. But I mean, it sounds like what you're saying is this section is and or should be specifically focused on the buried portion of that piping because that's the highest risk. It's highest risk for various reasons, one of which is it's out of sight, out of mind. And customers, I think, there does not tend to be widespread understanding that they're responsible for the buried portion of the pipe that's downstream from the gas meter outlet. Am I accurately summarizing at least one point that you've made?
Yeah, I mean, in terms of, I think our overall intent is to make sure we're scoping this appropriately and that it's clearly defined what actions the operator needs to take. And so, yes, when the meter is set at the customer home, there is some portion of above ground piping, customer piping. And again, that portion can be more easily visually, looked at and inspected. But again, I think, predominantly our take is that we just want to make sure that the definition is correctly scoped so that as we get farther into the notification process, it's clear what actions we need to take and what we don't need to take.
Okay. All right. Thank you for that. Mr. Schmidt, you have your hand raised. Please unmute yourself, turn on your camera if you can.
I don't think my camera works, Your Honor. I apologize.
Okay, that's fine.
It's
so go ahead and introduce yourself.
Okay, excuse me. I'm Dave Schmidt. I'm the Regulatory Compliance Manager with Colorado Springs Utilities. Been in the business about 35 years. In my early career, I have worked for both Excel and Atmos. And I've also worked for the Virginia State Corporation Commission and NiSource. My only reason for opening up is, Your Honor, just to give a little technical background and ways to think about why underground matters as opposed to above ground and what can happen. You have a customer-owned line. Customers are not familiar with the properties of the pipe in general that they're using, meaning if it's underground and it's steel, it's going to corrode. They don't have methods to check it. They don't understand it. If it's above ground, and that's why the below ground, above ground makes a difference. So if it's above ground, if it does corrode, if something happens, if it gets damaged, it's going to vent immediately to the atmosphere and should be noticed right away. If it's below ground, it has the potential to travel along the very ditch that it was laid in, maybe get to the structure or get somewhere else before it's noticed, and would have the potential to create more concern. When it's ahead of the meter, the utility, us, we're required to test it if it's steel for corrosion, corrosion testing. We're required to leak survey it and those kinds of things. So, just because it's downstream of the meter doesn't make those laws of physics change. The same kind of threats are still going to face it, but you're dealing with an individual that's not typically not set to deal with it, such as we are. But if it's above ground, and there are those kinds of things, I can offer an example where you call it a main extension and it goes up on top of a strip mall, and then you have your meters on the roof. All of that would be above ground, and it wouldn't have the same threat cases that below ground would. So there's just some technical background to think about why below ground matters, and can have different threats than above ground overall, and why we're concerned about the below ground portion of a yard line or piping or whatever we want to call it.
Okay. Thank you for that, Mr. Schmidt. I Appreciate it. So let me just ask, does anybody else have any thoughts about Colorado Springs Utilities' proposal to change the proposed phrase of customer-owned service line to customer-owned piping? Mr. Dixon?
Yeah, I just bring up something that occurred anecdotally. Back in 2011, I believe the utility was Eastern Utilities, which was acquired by, I think, CNG. They had gas lines that were made out of garden hose. I don't know if they're above ground or below ground, but my concern is if they were above ground, would they somehow be exempted from the definition? And that's the only concern I have. And again, I bring this up because it's, 13 years ago, but that was indeed in the record as being a factual activity that occurred with regard to those customary-only yard lines, that they were actually made out of garden hose. Not all of them, but some of them. So I point that out when you start restricting a definition. How does it impact? Is in fact that definition being restricted going to eliminate something that would otherwise be a customer-owned service line / yard line / piping?
Yeah. I appreciate that, Mr. Dixon. So, Mr. Stoffel, why don't you go ahead?
Thank you. To the question regarding customer-owned piping versus customer-owned yard line. So in addition to the gas infrastructure planning rules that use customer-owned yard line, for example, Atmos Energy recently established a quality of service plan that refers to customer-owned yard lines as well. And there's also a body of commission decisions addressing coils as these issues have arisen and evolved over time. And so I think Atmos would vote for maintaining that consistency with how that term is being used. And getting to the same ultimate point, I think that it's not being described as a service to help distinguish from a service. And then to this question around the underground piece, I was wondering that over the weekend too, if it really matters. And I think what we're struggling with is a general rule that says everything beyond the meter is the customer's responsibility. And then this additional obligation on behalf of the utilities and the operators to provide notice to customers with a certain kind of facility that is different than just the normal customer piping coming off the meter and directly into the house that may be just a couple of feet long. Now, so I think what we're trying to find is some subset of all of that customer-owned facilities that needs to be tied to this notification requirement, rather than it just being all customers getting notified that everything beyond the meter is their responsibility, regardless of whether that's just a couple feet or if it's, multiple feet under and above ground, potentially including garden hoses, as Mr. Dixon was just acknowledging.
Yeah, and all of you, I think, have provided some data about basically percentage of customers that have coils. And it's a small subset as a general matter of your overall customers. So, Mr. Stoffel, I mean, your point essentially is, okay, it's not too big of a financial obligation to provide notification to the small subset of customers that have true coils, whereas it would be a much bigger financial obligation to provide notification basically to all customers that all piping, everything beyond downstream from the outlet of the gas meter is your responsibility. Is that the point?
Yeah, that's exactly it. And then also, I think, a question of, is the value of that message diminished if it's delivered to everybody saying that they're responsible for everything, when it really is these more specific customer-owned service equivalents that are the area of concern and that should be getting this specific kind of notice and record keeping tied to it. Yeah.
Okay. So let me turn back to Mr. Akins real quick. Mr. Dixon raised the possibility that the scenario he laid out, I can't remember which utility it was, but basically of garden hose type piping from a gas meter to a structure that was remote from the gas meter was lying on the ground. And it seems to me, just looking at the definition that you've proposed of customer-owned service line, that would be excluded because no part of that line is buried. Is that fair? And of course, the answer may very well be, like you said earlier, I think you're not aware of any situation among public services customers that are analogous to what Mr. Dixon was highlighting. But go ahead, Mr. Akins.
Yeah, I think that's like an extreme scenario that's being presented here. No, public service is not aware and has not seen any of that situation where a customer has laid out garden hose downstream of the meter, on the ground, or even just, let's say, steel piping on the ground for that matter. I do want to point out that we do perform routine maintenance and inspection activities surrounding that gas meter. We would consider that an abnormal operation or abnormal operating condition. And we would flag that meter, turn off that meter, and notify the customer that we're not going to restore service until they have that pipeline reinstalled correctly with appropriate city and county inspection sign-offs on it as well. So I think that's a scenario that's unlikely for us to come across, just as a matter of point. And again, if we did happen to come across that, we would be taking certain actions to remediate that, even in that situation.
Okay. All right. Thank you for that, Mr. Akins. All right. So on this proposed rule 11205A, the definition of customer-owned service line, does anybody else have anything they'd like to say? I'm prepared to move on.
Your Honor, I've got my hand raised. First
Go
of all,
ahead,
the utilities themselves acknowledge they really don't monitor these things. Obviously if they see stuff, but part of the comments are that it's not their responsibility, and other than normal inspections where they would happen to see things. I'm not saying the garden hose example exists anymore, but it was clearly discussed in a case back in, I think it was 2011. It was Eastern Utilities was the name of the company, if my memory's right. And as I said, I think it was acquired by CNG. My point is, I don't know if we don't know that there aren't these things, if we don't know there aren't the possibility for above grind, I don't feel a limitation helps the definition. And even though I understand what Mr. Akins is saying, and I think it makes perfect sense, it's the question of, do we want to eliminate a possibility of something that's above ground all the way?
Understood. And Mr. Dixon, of course, you understand the point that Mr. Stoffel made, which was, and Mr. Akins made this point as well. I mean, this is relevant to as well the inspection and reporting requirements of the owners and or operators. So that's, I think, what they're trying to balance in their proposals. So Mr. Beckett has his hand raised, and I will turn to Mr. Beckett. Please introduce yourself.
Thank you, Judge Farley. David Beckett, Counsel for Carver-Sinks Utilities. I was actually in the process of trying to unraise my hand, given the statement that you just made, which was just to clarify that this definition is not intending to define all piping owned by customers behind the meter, but rather is trying to provide the context and the rules for when a utility needs to provide the required statutory notification to the customer.
Okay. Understood. Thank you for that clarification.
Your Honor.
Yes, go ahead, Mr. Stoffel.
This may be a situation where, in fact, both defined terms are appropriate. Customer-owned piping being everything beyond the meter, and customer-owned yard lines being the equivalent of services that the customers are responsible for.
Understood. Okay. Thank you for that. So does anybody else have anything on this definition? Go ahead, Mr. Beckett.
I apologize for the moving background as well. As my comments indicated, I'm not able to be in my office right now. The only thing I will add is that, and I've been discussing this offline with my client in the last few minutes. As this conversation evolves, and we very much appreciate Mr. Stoffel's point that he just made. Colorado Springs Utilities, had the luxury, given when we filed comments, to kind of see everything that had transpired before everybody else, and that was not by design. That was just reality. And that if the commission determines that it's best that this phraseology be in terms of COIL, Colorado Springs won't object to that. We just felt, based on Mr. Schmidt's experience, and we discussed some of the ways Colorado Springs Utilities uses its terminology, we felt that piping was a better fit. But we realized that this is an area where, so long as we have a clear rule, we will all know what it's intended to apply to.
Got it. Thank you for that, Mr. Beckett. I appreciate it. So, and I'm not seeing anybody else who wants to weigh in on this. So let me move on to proposed rule 11205C. The definition of gas meter, we've already hit this to a certain extent. And the proposal, at least one proposal that's out there, as I noted, was to modify the proposed language and basically the statutory language so that gas meter is defined as the meter that measures the transfer of gas from an owner or operator to a customer. And that is specifically Black Hill's proposal. Let me ask it this way. Does anybody disagree with Black Hill's proposed change? All right, I'm not seeing anybody pop up. So let me ask this. Does anybody want to make any further comment about this proposed definition of gas meter? All right, I'm not seeing anybody. So let's move on to proposed rule 11206. Give me just a moment. I don't think I have the right subsection. All right, well, let me ask this. Does anybody have any additional comments regarding any of the other definitions in proposed rule 11205? Okay, I'm not seeing anybody. So let me move on to rule 11206. And let me focus first on proposed rule 11206B, Bravo. And I'll just read the first sentence into the record. In addition to the requirements outlined in 49 CFR section 192.481, a visual inspection of gas meters and service regulators is required by a qualified individual no less frequently than every 5 calendar years, with intervals not to exceed 63 months. So let me just throw this out there. Why basically the two numbers here? So that sentence is saying that the visual inspection needs to take place no less frequently than every 5 calendar years, which I think is 60 months, with intervals not to exceed 63 months. Is that from federal law? Is that language from federal law? Can anybody explain this to me? And forgive me for if I'm being an idiot here, but go ahead, Mr. Akins.
No, you are correct. It's commonly how it's phrased in federal regulations is to allow for a little bit of a buffer for the compliance interval. It also helps limit, though, in some instances where you do, let's say, an inspection early 1 year and then try to defer inspection maybe till much later in that year. So it gives a little bit of a tighter boundary on when that compliance inspection or, maintenance requirement needs to take place.
Okay, well, and this is only talking about the visual inspection, not the maintenance that would follow, perhaps.
Sorry, sorry to interrupt. I just wanted to be clear. It's just a common format in federal regulations when it comes to requirements, whether it's inspection requirements or maintenance requirements and the timelines associated with those. So, to me, I think it's just an alignment of how it's commonly referred to in federal code when we're talking about deadlines of certain activities.
Okay, well, what it sounds like to me is it's basically saying, well, our expectation is that you'll do it, within 60 months, but you sure as heck better not go beyond 63 months. Then you'll be in trouble.
Again, if I may, it's just also, again, to help limit in some ways. Again, if an inspection took place, let's say in January, and then an operator elected to do, let's say, the following calendar year, if it was a 1 year requirement, but waited until December, you wouldn't have, let's say, 12 months in between those two activities taking place. It would be something more closer to 23 months. So again, it's kind of a way to help bookend that activity. So again, it not only keeps you within that year, but then it keeps you within a certain time period within that year from further delaying an expected activity that needs to take place. So hopefully that makes sense.
Yeah, I think it does. Okay. Anybody else have any thoughts on this? I don't think anybody proposed to change it, so just thought I'd get clarification if anybody wants to provide it. Mr. Akins, you've been helpful. Okay, I'm not seeing anybody pop up, so go ahead, Mr. Koshin, if you'd like.
Yes, Your Honor. It is tied to federal requirements. 49 CFR 192.481 A subpart 2 has the exact same language.
Okay. Well, I guess that's good reason to keep it then. All right. So let's move on to proposed rule 11206C. And this is the proposed language and I'll just read, this is from the proposed rule, the beginning of the proposed rule, the process for determining whether an owner or operator or a customer has responsibility for the maintenance and repairs of a customer-owned service line installed on or after August 14th, 95 and before March 1st, 2024. I guess my first perhaps stupid question is, we're required by the statutory changes to provide a process for determining this, which is why this proposed rule is written the way it is, I believe, at least in part. The proposed rule doesn't really seem to be explicitly defining a process. There is certainly a process implicit in the proposed rule. But I guess my question is, does anybody disagree with that? And to the extent there is no process explicitly stated, does that violate the statute? So let me add just a little bit. So in my view, a process-oriented rule here would say something like locate the outlet of the meter. The piping downstream from the outlet of the meter is the responsibility of the customer. The piping upstream, the meter and the piping upstream is the responsibility of the owner or operator. So it doesn't look like anybody has any comments, which is fine regarding my question, except for Mr. Dixon. Go ahead, Mr. Dixon.
Well, the last sentence is the process. That's what describes it. It's short and sweet. It may not be detailed, but I think that's the process that is being determined for what they are. So, I mean, I think that is the process. It's not detailed. Again, this goes back to commission rules can do interpreting. So if we need to do more interpretation, maybe parties have ways to add that without changing the statutory definitions. And because that's the point. Citing the statute over and over again isn't rulemaking. It's just repeating the statute. Theoretically, rulemakings are intended to interpret rules to make people be able to understand them better, which is why I suggested using definitions that we've all used and including those as examples of what a customer owned service line is, telling that the customer owned service lines are not owned by the utility is interpreting what's going on in the utility. So once again, this has a process that lays it out, and we had some considerable discussion about how it should be expanded. So I think it was referred to as broad, I believe, by Black Hills. So I'll leave it at that. I'm not going to go into the details, but that's my thought.
Got it. Thank you, Mr. Dixon. And go ahead, Mr. Akins.
Yeah, we just wanted to add on as well that, yeah, we think the process is the allocation of responsibility and maintenance. So we do feel like it's not in violation of statute and is appropriate.
Okay, thank you. And let me just turn to Mr. Kosian real quickly. So in Black Hills' initial comments, Black Hills made a proposal for owners or operators to be, basically responsible for all of the infrastructure up until the point that the meter or piping touches the structure that the natural gas is serving. So I don't want to go into detail on that, but my understanding is, Mr. Cushion, if you're still here, that Black Hills, based on the response comments, is not proposing any changes to the proposed rules based on the point that you were making in the initial comments. Is that accurate?
That is correct, Your Honor. The reality of the utilities simply taking on the risk associated with all pipe, specifically when dealing with coils, without the opportunity to address those risks on an individual basis, could be catastrophic to the utilities. Depending upon the number of coils that each utility has, simply adopting that risk and saying that risk is now on the utilities rather than the customer could be problematic. And so we are not proposing at this point to modify the rules for the utilities to adopt that risk.
Okay. All right. Thank you for that clarification. So I think I have what I need on 11206C. Does anybody have any further comments that they'd like to make regarding that proposed rule? Okay. So let me move to proposed rule 11206 D2C. And Public Service has proposed to change the reference to inspector to pipeline safety inspector. And I believe that Colorado Springs Utilities supports this. Looking to see if there's any other reaction from anybody. Go ahead, Mr. Dixon.
Yeah, I think it's a good fix. I just think it's an interpretation. And so once again, this is the statutory definition, does not have that the inspector has to be a pipeline safety inspector. But I think the commission can interpret this to say, because these are gas pipeline safety rules and gas pipeline safety standards, the inspector must be a qualified pipeline safety inspector. And I think that's an interpretation of the statute, doesn't take away anything from it. And is consistent with the fact that these rules are addressing pipeline safety. So, it isn't just a general inspector. So that'd be my thought, again, with the interpretational aspect.
Thank you, Mr. Dixon. Let me just ask Mr. Akins really quickly. So as I said, you all want to qualify inspector to pipeline safety inspector. What's the, what are we trying to protect against here, I guess is the question by qualifying inspector? What's the concern if it was just inspector?
I think the concern is just maybe an increase in volume of, other inspectors. There's a variety of them when it relates to a building construction or homeowner inspection. And so I think, those inspectors wouldn't have the purview of the pipeline safety regulations, the understanding, and also the necessity to understand what they're asking for. So it's, both the volume and just also to make sure it's the right appropriate person asking and interpreting the record for interpretation. So that was our point of view there.
Okay. Thank you for that clarification. I appreciate it. So does anybody else have any thoughts or comments regarding 11206 D2C and in particular public services proposal to change inspector to pipeline safety inspector? Mr. Schmidt, go ahead.
I just wanted to add that PHMSA itself, even as it administers its grant program, requires all of its state inspectors that are under the grant program and its own inspectors to attend T&Q, which is their training qualifications organization, so that their inspectors are all qualified. It's that important is all I'm saying, to make sure that you have somebody that is well aware of the industry itself and what it requires to operate safely. So, I think that just fuels the need for pipeline safety inspector and not just general inspector. If the government agency charged with overseeing it requires that of their own personnel, I would think we'd want to require it in our rulemaking as well. And that's it. Thank you, Your Honor.
Yeah, thank you. That was helpful, Mr. Schmidt. And Mr. Dixon, why don't you go ahead?
Yeah, consistent with what everyone's saying, there is no definition of inspector in the statute. So the commission has the authority to define what an inspector is. And otherwise it's ambiguous, as we've all talked about. It could be, traffic policeman. It could be anybody who's called an inspector. I'm using odd examples, but I would say this is a great place for the commission to define what an inspector is and what they expect an inspector, what qualifications that inspector would have, so that people would be knowing who to give it to.
Understood. Thank you, Mr. Dixon. And to be clear, my thoughts regarding this did not have to do with, what the commission's authority was with respect to defining inspector versus pipeline safety inspector, but I appreciate the comments. So I'm not seeing anybody else coming up. So Mr. Domenico has raised his hand. So go ahead, Mr. Domenico.
Good morning, Your Honor. Harry D. Domenico with CNG. We just like to express support for the change by public service. We think that that's a good change, and that's all I really had to say.
Great. Thank you. So I tell you what, we've been going for about an hour and 15 minutes. Why don't we take a break until 1:15. So we'll be in recess until 1:15. Thank you. All right. Ms. Wiesenthal, are you still here and ready to go?
Yes.
And Ms. Federico, are you ready to go?
Yes.
Okay, we're back on the record in the Colorado Public Utilities Commission's proceeding number 24R-0078 GPS. So what I'd like to do is somewhat quickly run through a few of the remaining proposed rule changes. And at the end, I'll open it up and see if anybody wants to make any additional comments regarding really anything within reason. So anything within the proposed rules that we haven't already touched on, or other proposed changes by other parties that I may not have hit on. So with that, let me turn to proposed rules 11206 D1 and 3, and specifically the reference to best efforts in both of those proposed rules. And those are best efforts undertaken by the owner or operator. So there's been some written by some of you in your comments about perhaps trying to provide some detail on best efforts. I don't think anybody's taken a hard position on this, but I thought I'd open it up for any comments regarding best efforts. And I'll tell you what my inclination is not to attempt to define best efforts, because any attempt is just not going to work, because I think best efforts is malleable and it's highly context dependent. At least potentially. So anybody have any thoughts about that? Want to provide any further comments? Okay. So let me move on. And let me just ask, and again, I don't think I'll get any comments on this, but as Colorado Springs Utilities, didn't provide initial comments, they did make a proposal in their response comments, which was to add best efforts to Rule 11, proposed Rule 11206 D3. And I'll just read, at least in part, what they're proposing. The proposed rule currently says, if the owner or operator fails to obtain a copy of the written notice described in paragraph D of this rule with the customer's signature, and then he goes on. Colorado Springs Utilities is proposing to add in, if after best efforts the owner or operator fails to obtain, etc. Anybody have any comments about that? Okay. Let me move on. Give me just a moment. Okay, let me focus more on proposed rule 11206 D2D. That's the proposed rule addressing the obtaining of a new customer signature on a written notice. And again, what I'd like to do is just open the floor to proposal made by Colorado Springs Utilities in their response comments. And as I understand it, and correct me if I'm wrong, Colorado Springs Utilities, but what you're proposing here is in the proposed rule, the notice with signature applies to well, it applies to the customer. And I think, give me just a moment here. Okay, so yeah, the current proposed rule, 11206 D2D, focuses on change in ownership and the obligations that are triggered by that. I believe Colorado Springs Utilities is proposing to basically eliminate the obligations being triggered by the change in wealth, change in ownership to the notice needs to be applied to all customers, irrespective of ownership. So if there's a change in the customer, the notice requirement in proposed rule 11206D 2D would be triggered. So anybody have any comments about that? Anybody support that? Anybody against it? Go ahead, Mr. Stoffel.
I don't think Atmos supports or opposes. I think the real challenge is that change from customer to owner tracks the statutory language. And so I think we're kind of back in this situation of trying to navigate or interpret exactly what the legislature intended there. But the other provisions referring to customer notice refer to customer. And then there's the specific one about change in ownership and notifying the owner.
Got it. Okay, thank you for that, Mr. Stoffel. Anybody else want to provide any comment on that? Okay. All right, well, that's what I wanted to cover today. There were obviously other proposed rule provisions and also at least some suggestions from some of the commenters regarding changes to those other rule provisions. But I don't really have anything to ask regarding any of that. I think I understand everybody's position. So at this point, what I'd like to do is just open the floor and see if anybody has any additional comments that they'd like to make about anything within reason in this rulemaking. All right, well, I'm not seeing anybody who wants to make any further comments, so let me tell you what the plan is. I'm going to continue this remote public comment hearing until June 24th at 11:30 a.m. And what I'm going to do before then is issue an interim decision with some further proposed rule changes in light of all the comments that the commission has received both in writing and today. So I will issue that decision and then provide an opportunity for a second round of comments from anybody who would like to provide them. And those are written comments to be filed, and I'll specify in the interim decision the deadlines for the initial comments and then the response comments in the second round of commenting regarding the changes that I will propose in the interim decision. So does anybody have any questions about that? Any comments? Okay, I'm not seeing any. So let me just say thank you to all of you for participating today, providing your comments. They've been helpful to me. And this remote public comment hearing will be continued until June 24th at 11:30 a.m. Thank you very much.